the engagement that we're seeing, and that's all under existing law. And prior to the most recent version of the bill, there was what I testified to on the House side, there was a misdemeanor that was included in the introduced version, and in part because of testimony that was provided, we noted that a lot of the conduct was really mostly entirely captured under the existing criminal code. So they took the misdemeanor out, they included the civil fine here. And from a practice perspective, we do see that handing out a civil ticket might be a really helpful first way to de-escalate an individual. Let's just say it's 2 or 3 people and they're blocking, they've got signs that clearly show the reason why they're doing what they're doing. And a police officer doesn't have to call us. They can just say, hey, here's a ticket, because you're getting in the way of a person seeking protected health care. So we do see that as a really helpful middle ground. And of course, if it escalates, or even at the first instance, there could be criminal charges depending on the circumstances.
There's one event, by the way, Albany Medical Center had an incident Monday where a patient's relative made threats to the workers in the hospital. Then I assume he had a firearm, locked himself in the patient's room, and they had a complete lockdown of the Albany Medical Center for 12 hours or so. So that type of behavior in Albany, New York, no reason to believe it couldn't happen in Vermont. So I'm mindful of that. These types of protests can often lead to that type of behavior.
And I do think some of what you've done with S36 actually could be helpful in some of these circumstances, because it provides instantaneous clarity to law enforcement, state's attorneys that are getting those calls about the 3 areas that you talk about in S36.
I'm the one that raised the issue, though, of how this would interact with, and you're saying because this is civil and not criminal, then my dislocated shoulder is still an issue. That wouldn't confuse the Supreme Court as to the terms of legislative effects.
I will never speak on behalf of the Supreme Court, but I would say that from my read of it, what it would do is the officer could only hand out the ticket here for the 2 categories that Attorney Childs testified to, but it certainly wouldn't stop a police officer from issuing a criminal citation if they're engaged in any of the menu of criminal conduct options, including, as noted, potentially the hate motivated. If they're there, and not only are they not leaving after the officer gives them a ticket, but they're escalating and saying, I'm here because I want to prevent you from going in and receiving healthcare activity. There's an argument to be made there, depending on it, if it's very particularized, that it could be charged in an elevated way as well. So I do think your existing criminal code really covers the universe of conduct that's in there. I did want to note just a comment that I made on the House side about knowingly. It is an elevated mental state when compared to the word recklessly. And I think it's fine in terms of the list, where you've got purposefully and intentionally at the top. Those are the highest burdens. Then you have knowingly, and then you have recklessly. So knowingly is not the highest burden. It's not the lowest burden. That's a policy choice for this group. And the House had knowingly in there from the beginning, which again, we don't have a comment on, but we just want to note where it lies in that mental mens rea kind of area. But other than that, I think very brief testimony. We appreciate all the work that's gone into this and your testimony today. It's, this body's prerogative to try to set the intentions. And obviously, there's staffing issues that law enforcement, state's attorneys are dealing with. And so I actually think the civil ticket option is really, in a way, pretty great, because it provides law enforcement can do that immediate ticket for these types of conduct related knowing areas. And then if it escalates into the criminal conduct, we can always go down that road as needed. And that's really it.
So your testimony is you're satisfied with this version of the bill as passed out?
That's correct.
Good. Thank you. Other questions?
So, question: can you just touch surface level on extradition? And we heard some testimony about it from Ledge Counsel about how our hands are kind of tied in that area as a state's attorney, can you just share your thoughts on that?
So in a situation where it could arise in practice under current law is, it happens with New Hampshire a lot, New York, the border states where people are going back all the time. And I will say, for the most part, there's a lot of agreement with the criminal codes in the Northeast in terms of levels of punishment and similar types of criminal conduct that is treated in a similar fashion. So I do think some of this will need to be sorted out, by the courts in terms of this new exception, so to speak, in the criminal extradition environment, because it's possible, given that this is in some ways a political issue with overlap to healthcare, that a governor in another state will say, and it's just possible, I'm not saying this from the behalf of the state's attorneys, that, well, if you're not going to send us this person, we're not going to send you this person. And that's something just to think about. A governor's warrant process is not necessarily a very quick process, even for very straightforward situations. I had someone that stole a vehicle and then escaped to New Hampshire, and they had 15 or 20 pending situations here in Vermont. And it took about 90 days to get the extradition from point A to point B and get the person back here. And they can always waive extradition. But I always call the Attorney General's office whenever we get an extradition case, just to make sure that we're, comporting. And this would be just a new wrinkle. And again, I think there's value in setting the intentions that you're doing here, but I think it really will depend, and non-legal related, but governors are the ones that issue those warrants. And so that is inherently something that is going to come into play.
Thanks.
Yeah.
Thank you, Tim. Other questions? Thank you, Judge Zornay.
Good morning.
Good morning.
Tom Zonay, Chief Superior Judge. I think I can be rather brief. First of all, the statute that this bill talks about a policy. And it's a policy, as we've heard this morning, that is one that is attempted to be addressed by a number of different statutory enactments. The court did participate in the House as far as testimony, and while not weighing in on the intent or the merits of the statute, what we did do was work with the justice partners and the committee to make sure that the language that they were choosing to effectuate the intent of the bill was language that worked with the courts, and that came down in areas of whether it was the language they were seeking for discovery, materials here, judgments, things like that. So we did work there. Beyond that, we've heard quite a bit today about the extradition, full faith and credit. If you have any questions on that, I'd certainly be happy to address those. Senator Norris, as I know your question is, how's it going to impact the courts? And as I'm sure you know, we don't know. We don't know how many cases there would be that would come up. So it's difficult to assess whether this would have a significant impact on the courts at this time.
Could I, Mr. Chair?
Yeah, sure.
I'm just wondering about abusive litigation. And the definition, as I see it on page 3, is abusive litigation means litigation or other legal action to deter, prevent, sanction, or punish any person engaged in legally protected healthcare activity by, and so on. I'm just wondering about how a court would go about differentiating abusive litigation from litigation, which people may bring for a whole host of things, one of which might be to delay or deter. If there's an Act 250 question in your neighborhood, you may engage in litigation to delay or deter the outcome. So I'm just wondering if you can tell me your thoughts on that concept and how easy or difficult that might be to prove.
It's difficult to assess whether it's going to be easy or difficult. In some circumstances, it may be very simple, but it's going to be fact driven. When a court is determining, when it talks about what's the intent, as you point out, is someone doing it because of delay? Well, how do we discern that? Well, we discern their intent by looking at the facts, and the facts come in through the proceedings. And so it's difficult to assess whether or not someone has the intent sometimes right from the pleadings. So very fact driven.
Okay, fair enough. just something that I stopped on when I read
And
through.
some of the litigation may also be on its face. It may say, well, we filed this lawsuit, we keep hearing about Texas. We
Mhm.
filed this lawsuit in Texas under SB 8, and therefore, well, that one on its face, not a lot of facts to find out there, because it's very clear that that is absolutely what this bill seeks to address.
Yeah.
So there's kind of those extremes on the continuum.
Thank you.
Okay. Next is Marshall Hall, the Defender General, and juvenile.
Thank you. I will be very, very brief. We have no opposition to this bill. We testified on this bill in the House because it originally included a misdemeanor, a new misdemeanor offense that was in section 4. That was changed to a civil ticket, and that at that point does not affect our office anymore. And so as long as that remains the way it is in the House passed version and not as a criminal offense, then we have no objections.
Good job. Wow, my goodness.
Thank you.
You're welcome, thank you. Alco Schilling. Embassy Director, ACLU.
You also have 15 seconds.
All right. I mean, I probably could do it in 15 seconds. I might take a
I
minute or
hope
two longer than
that
that.
240 goes as quickly.
Yeah. So thank you for everyone for having me here today. For the record, my name is Paul Schilling. I'm the Advocacy Director for the ACLU of Vermont. And I think this is the first time I've had the pleasure of actually testifying to you all in person. So it's great to be here and great to see you all. And I think kind of building off of the theme of the morning is we are very supportive of this piece of legislation. It's something that we have worked on in collaboration with providers, House leadership and others, looking at what types of bills have passed in other states and what do we think is most effective, while also trying to balance a number of constitutional concerns. Because as you've heard this morning, this is really at the interplay of a lot of different pieces of constitutional law that require balancing. So we have folks who have similar jobs to me in states across the country who are parts of working groups looking at what types of laws make the most sense, what are the limits, and what can we do to pass something that offers the highest level of protection we can for patients and providers, while also observing those areas where we don't want to run afoul of the limits within the Constitution and put ourselves in a place where we have a law that's not defensible. So I think the House has done a very good job balancing those concerns. As you've heard, there's been a lot of deliberation around that. And we also appreciate the specific focus in this piece of legislation on reproductive health care and gender affirming care, because as you've heard, these are activities that are being targeted by legislatures across the country. It's difficult to know exactly how this will all play out because we don't know what other states might pass. So this is based on our best understanding of the types of legislation that's out there now and what we can do to try and help protect those. So I think when we're looking at those themes, one of the biggest themes, what we can do is what we call non-cooperation. And you see that kind of throughout the bill. There are areas we're saying we're not going to be expending state resources to try and support the policies of other states that run directly against the policy of our state, and for people who are engaging in activity that's legally protected here, fully legal within the state, and so therefore we're not going to be using state resources. So that in itself does not run afoul of the full faith and credit clause. Where we've seen other states attempt to try and do this type of litigation, and what we think is a less effective means is saying things like we won't uphold judgments from other states. That is more problematic when it comes to full faith and credit. So we appreciate the tack taken in this bill to go with what we would refer to as like a clawback provision. So it's not saying you can't bring a suit from another state and we will not recognize the judgment from another state, but it's saying if you bring that type of action, then we have a cause of action here in Vermont where you can basically counter sue. And so I think in terms of deterring invalid lawsuits that are against the actual policy of the state of Vermont, that's a good way to go. And it allows, there's a question about what will this mean in terms of access to attorneys to bring these types of suits. I think when we look at the language within the bill, It does allow for attorney's fees for folks who, and for actual, the damages incurred within the suit. And then actual fees on top of that, which for an attorney is something that they would, helps incentivize taking cases like that when they know that if it's, clear on its face, you're being sued under SB8 for activity that was fully done within the state of Vermont. I think that's a case that an attorney would look favorably on possibly taking. I will note, and I think this is something worth understanding, is a policy choice that throughout this bill, it does try and protect provision of services to other states, to people in other states through means like telemedicine, provision of those healthcare services to people who might be beyond the borders, but if the providers within the state of Vermont, we're saying that's protected. We would just, it's one of those things where since these laws are largely untested, we want to make sure we, of course, advise any provider thinking about engaging in that type of activity to make sure that they have their own legal counsel and understand the risks involved with that, because this is new, this is uncharted waters. But I think in terms of the goals of this legislation, the goals of the state to be as protected as possible, those are things that we fully support. Though I think we also recognize that those are places where you would want to get your own legal counsel before engaging in those type of activities to know what your personal liability might be, because we can't go through every single scenario. And then on top of that, we also appreciate the changes made in-house and referenced by the Defender General's office to make the obstruction of trying to access legally protected healthcare activity, making that a ticketable civil offense as opposed to a criminal offense. That's something we also asked for. And I think they've also strengthened some of the language around there in when it comes to balancing the right to assemble versus actually trying to get legally protected healthcare activity. And your talks about threats, physical force or physical obstruction. And so tries to strike that balance. And with the current language in there, we don't have an objection to that at this point in time. And then generally the final section of the bill, we're trying to help protect the information of folks, patients and providers who are in support of that as well. So that was a longer way of saying we support this legislation, but we're happy to be, as the bill goes through deliberations, happy to provide any more information we can, or to answer any questions you all might have of us.
I think it's great. Thank you very much.
Thank you very much.
Rebecca Cook. Hi, Rebecca.
How are you? Rebecca Copans, with Blue Cross Blue Shield of Vermont. I just want to apologize, Sarah Teachout couldn't join us, I'm pinch hitting, so I hope you're kind and gentle with me. So Blue Cross we do our best to support our members' values, and this bill is clearly in support of our members' values. So we support access to reproductive and gender affirming care services, and they're covered in every one of our health plans. As the Dobbs decision was coming through, we were one of the first insurance plans in the country to speak very loudly and clearly about that decision. And we moved quickly to provide a travel rider for our customers who, we support a lot of employers, large employers in the state who have employees outside of Vermont. So we created a travel rider. So if someone is in Texas, they can travel to another state to receive gender affirming care and abortion care. So for example, if one of our members has a child who goes to school in Texas, they can go to another state to receive care. So the one piece that we are concerned about, which Michelle raised earlier, is payers is a broad term. So we are a payer as an insurance company, but employers are also payers because they provide self-insured care for their employees. So we would prefer that the definitions be aligned in the two bills to include Section C of more explicit about insurance coverage for employers. More explicit more explicit about what health coverage means. So it's section C of S37.
Okay, maybe Michelle, Claire.
I wasn't sure if you were here for my walkthrough, so I walked him through S37, so I think the assumption is that the S37 definitions
Will carry.
be imported.
Okay.
Because they need to be, they can't conflict, they've got to be the same.
That's great.
Yeah.
That's our only requested change.
So that will change.
Yes.
Great. Yep. And thank you for welcoming us here. Appreciate it. More questions?
Okay. Thank you.
Thank you.
So that's amendment number 1. Maybe no more. Jessica, go ahead. Executive Director of the Vermont Medical Society.
Yes, thank you very much. Hi,
Nice
Jessica.
to see you.
Nice to see you. Oh, there's another.
There's another.
Oh, is it not? Do you want to, Jessica next?
She is. Okay.
Wrong, Jessica.
I did that. I said just, yeah, okay, Jessica Barquist. I'm sorry. Too many Jessicas. Me.
Or just enough.
That's right.
No worries. Hi all, Jessica Barquist, Vermont Network Against Domestic and Sexual Violence, and I will be very brief. We support this bill. At the Vermont Network, we work to promote policies that support victims and survivors of violence to thrive and live lives free from violence. We also represent the 15 member organizations, of which one is Pride Center Safe Space Anti-Violence Program, which provides direct support to LGBTQIA+ survivors. Our organizational mission is to uproot the causes of violence and build a world free of oppression, where actions, beliefs, and systems support all people to thrive. H89 creates needed protections against violence so that all in our communities may thrive. Victims and survivors need body autonomy, especially as it relates to their medical care. Gender affirming and reproductive care is essential health care, and those who receive it and provide it need to be allowed to do so without the threat of violence. And I just want to highlight, two quick sections that we are strongly supportive of. The first is explicitly adding gender affirming care as legally protected healthcare activity. Estimates show that we have over 3,000 transgender individuals living in Vermont. These individuals are among the most vulnerable to harassment, victimization, and violence. Trans individuals who receive gender affirming healthcare are able to live lives in alignment with their true selves. We know that people who live happier, healthier lives are less vulnerable to violence and harassment, including sexual violence and trafficking. Gender affirming healthcare is essential medical care, and we need to make sure that it remains available to all who need it. And then the other piece I want to touch on quickly is the address confidentiality program. As you probably all know, the Secretary of State's office has long housed the state's address confidentiality program called the Safe at Home program. This program is currently available to victims of domestic and sexual violence, and victims apply through the Secretary's office, and then they have 4 years of address protection with the option to reapply. This has been a really valuable protection for individuals to keep the location of their home secure from those who might harm them. It provides survivors who are part of the program with a sense of safety that everyone should be able to experience in their home. So we wholeheartedly support the expansion of this program to include healthcare workers providing essential care to their communities. And that's all I have, but happy to answer any questions. Thank you all so much.
We did have some discussion about Section 8, the address confidentiality for victims. I think the committee is very supportive of that section, but wanted to make sure that it works. Thank you for your comments on that section.
Absolutely. Yeah, I know we have many survivors who use it and find it very effective.
Yeah, no, I want to be clear that I very much support that. And my concern is really about thinking more broadly about how we protect healthcare workers. And in no way was I suggesting we shouldn't do this, just that perhaps maybe we actually should do more.
Thank you. Now, just.
Thank you. Sorry for jumping in order there.
No, that was fine. That was my Vermont Medical Society and.
Yes, thank you.
Thank you.
Jessa Barnard, I'm the Executive Director of the Vermont Medical Society. It's also my first time in this committee this session, I think. So thank you for having me. We represent physicians and physician assistants across the state. We're also the home for a number of specialty medical societies. So I'm testifying not only on our own behalf, but for the American Academy of Pediatricians, Vermont Academy of Family Physicians, and the Vermont Psychiatric Association, which has psychiatrists as its members. And all of our organizations are strongly in support of H89 as passed the House. We collectively represent approximately 3,000 physicians across Vermont, including those who provide gender affirming and reproductive healthcare services. And I do want to mention, we spent a little more time on this in the House, and it's and also on S37. It's certainly come up in questions, and probably if you are hearing any comments from constituents, I just want to state for the record that both reproductive services and gender affirming care are absolutely evidence-based medical services. And I've linked to some of the clinical best practice guidelines, both from American College of Obstetricians for abortion and reproductive services, but also the Endocrine Society around transgender care and the American Academy of Pediatrics. So those are Endocrine Society is kind of the gold standard of evidence-based services for adults, and then the American Academy of Pediatrics for children. And I will, Senator Sears, back to one of your questions early on in the walkthrough, want to differentiate, or one of the reasons that conversion therapy is excluded is not an evidence-based practice. That is sort of as the Alleged Council stated, kind of the opposite of gender affirming care. That's trying to basically convert you back to the identity you were born with, or the gender you were born with, and that is against state statute now in Vermont. And so really I think that one of the purposes of including that is saying, that is against state law, and we don't want to then be sort of inadvertently protecting that type of service.
I was basing my question on a lot of the emails I've received.
I don't doubt that, yes. So just to state that our members, the medical professionals of Vermont support that differentiation, and the current definitions of the bills. We actually, so we've had some of our obstetrician and other members who testified in the on S37 and in the House. So if you'd like to hear from any physicians about in more detail about sort of the evidence or what is evidence-based
I suspect
care.
Next week we're going to hear from a lot of those.
Sure, we're happy to help arrange for that, and they could go into more detail on the clinical aspects. I'll say based on those evidence-based guidelines, we have established policy positions supporting access to contraception, abortion, and gender affirming care. You've already heard some of this testimony, but I also wanted to provide some more references about how these procedures are under attack in other states. So about half of US states have already or are expected to enact abortion bans or other limits on the procedure. And similarly, more than a third of transgender youth age 13 to 17 live in the 15 states that have restricted or banned access to best practice medical care for transgender youth, or are considering legislation to do so. And there are some good kind of charts that I've linked to that go through all of these types of statutes that these states are passing. And I said they vary, but many of them carry significant criminal penalties for the healthcare professionals who provide such services. So as Legislative Council also pointed out, fewer of them kind of go after the patient, him or herself or themselves, but more the provider of care to either say these are now criminal procedures or carry civil penalties, or what S37 addresses, licensure penalties. So professional discipline. Some of them include decades of prison time and tens of thousands of dollars of fines. And we've also heard reference to SB 8, which is a novel attempt to say that any private citizen can sue someone who performs or induces or aids or abets in the performance of an abortion. So our members feel that given these realities, and knowing that many patients, because of these laws, already are or will continue to need to travel outside of their home state to obtain these services, we strongly support the protections for the patients, individuals who are assisting them, or the providers of care. We support the protections from out-of-state prosecution and extradition, protection from enforcement of civil judgments, subpoenas, and warrants to the extent that Vermont can. We believe that along with S37, this will put in place important protections. We want to highlight a few of the sections we think will be particularly important. The section around tortious interference claims, and we believe that's really important to be able to deter intimidating legal tactics or to recoup legal expenses. And I appreciate the ACLU mentioning the attorney's fee provision. We think it is important that that's included to be able to make sure that healthcare professionals can take advantage of these types of kind of counter intimidation tactics. We also strongly support the Section 8 address protections. We reached out to some of our members when this was proposed in the bill early on, and some of our OBGYNs in particular weighed in strongly in favor of this. I included a quote from one of our members saying, you know, she was trained, she provides abortion services. She was trained early on to never put her home address on any medical license applications. And that she has colleagues who bought houses through trusts to avoid property disclosure records. So I think that it's as you pointed out, Senator, it's hard to even know how some of this information can become public. And so to have one address that you can use that is a private address or a protected address is extremely important. It does not, as you're correct, address all of the license protections. So I do think Lauren Hibbert can address that more, or David Perlicki with the Board of Medical Practice. My understanding is that the boards do try to be supportive of ways to not disclose a home address. I think this would be one option if you only have a home address. For example, if you're working from home and don't have a business address, I do believe both provide the ability to only list a work address as opposed to a home address becoming publicly available. And they try to point out if a provider actually lists a home address. I think they often will even try to reach out and say, are you sure you want to list this address as the publicly available address that would be on our website if you search for your license information, things like that. I do also want to point out, this has come up in questions. I know as these bills have been moving the way through, there is nothing in H89 or S37 that changes the standards of care for these medical services. And there is nothing that changes the law around consent for care by minors. That is in other provisions of state statute, which healthcare services minors can consent to. And there is nothing in either of these bills that touches that or changes that in any way. So I know, again, that's been some concerns raised with these bills. It's really about protecting the services that are already legally available in our state, protecting those patients and providers who access them or provide them. So happy to answer
Senator.
questions.
I
Yes.
think that pretty much covered the questions that I was going to ask. And just to clarify, when you say standards of care, those are the professional regulations and requirements that doctors and other providers have to follow when they're providing this care. Is that
correct? So which are really established by often professional societies.
Mhm.
So for example, in this case, the Endocrine Society has has guidelines around gender affirming care. The American Psychological Association, I believe, has guidelines for psychologists around gender affirming care. So those would be kind of the professional guidelines. And then the professional licensing boards are really the entities that then uphold those to say, is there an allegation that you were not acting up to the standard of care? And they would look to those types of professional guidelines. They would have experts, other professionals in the same specialty to testify to say, yes, you were meeting the standard of care, or no, you were not. So that's kind of how professional standards, I would say, get either determined or kind of upheld. And again, nothing in this bill that I see changing that in any way.
Thank you.
Thank you. Any further questions? Great.
Thank you.
Thank you all very much. That concludes testimony on H89. And we're going to take up amendments from the House, The Senate Health and Welfare Committee has looked over S91 and 89, and we're going to try to take up those amendments as soon as somebody can come in next door. Yeah, but in the meantime, we could have a little discussion about the future. It might help. Senator Hashim and I have a meeting with the House Judiciary team at 12:15. And we have, obviously, the priority is all the Senate bills. but I'm sure the House will like to see this bill and what is the firearm?
230.
230. It's called reducing suicide. And it obviously is controversial. And yesterday in the chairs meeting, we had a discussion about how much time we have left, which isn't as much as this senator would like, but it never is. We're going to be basically down to 2 to 3 weeks left, counting this week. In other words, the 14th, somewhere around the week of the 14th, it's going to get more difficult to meet. The week of the 17th, we'll still meet, but our time will be limited more, I would guess.
That seems early to me. I mean,
Jane said she wanted the budget out by the 21st.
right, but I think if you're talking about morning committees,
Yeah.
I think what we talked about in chairs was the last 2 weeks of May, or I'm sorry, the first 2 weeks of May. So we would have more, as opposed to 2 or 3 weeks, we might have 3 or 4 weeks.
Okay. Well, that's a little better.
Mhm.
You know, I'd like to do the Uniform Power of Attorney Act. I know it's important to Representative Lamond and our attorneys in the state who do probate work. And it's a long bill. It's uniform, so it's usually not too controversial.
And I did also hear there was 288, the liability for alcohol beverages. I know there was a very quick push for that in the House because of some places that were in a very bizarre position with their licenses and were at risk of closing down.
Well, I think there's an amendment to that will be coming from trial lawyers very concerned about the way the insurance works at brand shops. Senator Bowles.
Yeah, absolutely. So I'm sure people saw the 7 Days article last week that put us yet again breaking a record of overdose deaths.
Yep.
For another year in a row. And I'd really like to see us look at some of the places where we can take action now to prevent deaths. And one of the places would be potentially in drug checking. It's in one of my bills, but I think we may be able to add it into a House bill. And what that would require from this committee, so it would be a collaboration with healthcare, it would require an expansion of our Good Samaritan laws to provide immunity to people who are getting their drugs checked or providing those checking services. And I'd love to see if there's a place we can work that in so that we can stand up the space for people to actually be able to take whatever product they have in to be tested for safety. It's shown to be more effective than the test strips, especially with the newer products that are coming online that are killing people. And so I just want to make a pitch that we look for a place to do that work.
Yeah, I don't know where I'm looking at the titles of the bills.
The suggestion was and I've been in conversation with Senator Hardy about this as well. The suggestion was for H222, which is going to be used as the vehicle for the opioid settlement funds, which we could also use. And this is why I say it would be a collaboration, because they would stand up the sites in that bill, but we would have to expand the Good Sam laws to include the immunity aspect.
Well, we'll certainly only look at it. It's just a
Awesome.
matter of time.
Yes, I just wanted, while we were having this conversation, I wanted to put it on our priority list.
And,
Well, how
48,
close is that marriage bill?
that's tomorrow, isn't it?
I think
Yeah.
I could do it tomorrow.
Okay. I don't the non-consensual removal of condoms, is that?
I feel like that's a pretty easy one.
Yeah, we've already done 41, right? Or we need
We
to,
still need to hear from a few witnesses, but I think it's in good shape.
okay. The driver's license suspension got scheduled.
No, it's about time. Looking forward to that one.
Personal.
No, just.
I was like, Mom, did
Just
you
getting away
speed
from
home
everything
the
else.
other day and get yourself in trouble?
No.
Are there any others that are priorities for any members of this committee?
Well, I would say 230 is the only one that,
Well, I'm assuming we're
Yeah.
at least gonna take it up. I don't know how I'm gonna vote.
Yeah. I
I'll
would,
be honest, from the beginning, I know we're live. I've supported waiting periods, I've supported other measures, but safe storage is a very difficult issue for me to get my arms around, because I don't think it's enforceable, number one. Number two, it leaves all kinds of the constitutional questions for me about the right to defend yourself. I'll just be upfront about that. That's the
Yeah.
one part of that bill that, I don't know what else is in the bill, but I do, I have supported waiting periods. I have, on other stuff. So. Well, Eric,
Morning.
nice to see you here.
Nice to see you as well.
So anyway, I don't know where other people are at on that bill, but that's where I'm at.
I haven't seen the bill, so I've heard about it, but I haven't seen it.
We don't need to comment now, but
So if I've learned anything, it is that I need to see the actual words on the page, because what I'm hearing may or may not be an accurate representation of what they are.
I've heard it's well written, whatever. So.
I'm
we're actually.
sure that it is.
Rumor around the building.
he's got Fitzgerald.
That's right.
Alright. These are Senate the Health and Welfare Amendments to S91. You want to go over them with us,
Yes,
please?
absolutely happy to. Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel to review with the committee the proposed amendments that Senate Health and Welfare is looking at, and they looked at this final version this morning, and they all approved it. And the version that you're looking at now probably just has Senator Lyons' name on it, but the one that they approved has all committee members' name on it. Other than that, it's identical to the one that you're looking at now. So there are two, the only changes are to the competency restoration program piece and to the Justice Oversight Committee review proposed for this summer. So the first one involves, is pretty straightforward to see it on page 1. Just remember that the idea behind that was that DMH and Dale was going to report back on whether or not a competency restoration program plan should be adopted in Vermont. So that was their first directive, whether or not to adopt the plan. And after that, if they decided that a plan should be recommended, then they would include recommendations for best practices, necessary legal changes, costs, et cetera. And so the only proposed change here from Health and Welfare is that it wouldn't just be the departments, they would be in consultation with interested parties. So you can see that on line 7A. Second series of amendments relates to Justice Oversight Committee study. You remember that what Justice Oversight was going to study related to the idea of broadening the types of professionals who can conduct that initial psychiatric examination and competency and Sandy. So I think this committee had decided on doctoral level psychologists with training in forensic psychology primarily. And so the idea was though that it would sunset after a year. And during that interim period, Justice Oversight would look at it and see and think about whether that's working. Should it be continued permanently? Should it be repealed, or should it be expanded to include other professionals who might be also able to do that initial psychiatric evaluation? So that was what came out of this committee, and the couple proposals that they made, or suggestions they made to amend that involved. Well, first one is the scope of the review, and that's on page 2, on 3 to 6. just specifying that the review would include consideration of other laws on the issue in other states. So in other words, I think this committee even heard some testimony on that other states tended to allow others, professions other than psychiatrists to conduct
Vermont
that.
and Rhode Island are the only
That's
states
right.
that don't.
That's right, exactly, right. And so I think the idea was to just review maybe what other professions are permitted in other states as well as part of that justice oversight review. And also, you see this last phrase, the reason that's in there, whether any changes are necessary to permit referral of the evaluation to a psychiatrist when appropriate. The topic that came up was, what if, maybe because of an underlying medical condition, there might be a situation where it really should be a psychiatrist rather than a psychotherapist or psychologist, sorry. So they just wanted to make sure that that was considered when justice oversight looks at it this summer.
Yeah, I'm not sure justice oversight's qualified.
Right, right.
So basically, from our version, we had psychologists as folks who could perform the competency
Right.
evaluation.
Yep.
And they took psychologists out. Is that what I'm hearing?
No, that part's still in. This was just expanding the study of
Are
who
there
else might be
people-
included.
Okay.
I'm assuming this means, are there defendants who, for whatever reason, need to have a psychologist, a psychiatrist do the evaluation rather than a psychologist?
Exactly.
I think 1 and 2.
The problem is, how would the
page 2.
court determine that?
Yeah, it's a good point. I
That
think,
comes to my mind. So,
Right.
I mean, I don't mind this language here, but my first question when it comes up in justice oversight is, how would the court determine which cases should be seen by psychiatrists versus a psychologist?
right,
I suppose if the person had a heart condition, that then why wouldn't you have, I'm gonna say Dr. Wilkie. He happens to be the Bennington
cardiologist.
cardiologist. You would also have this person seen by the cardiologist, not necessarily. I don't know what medical condition.
Yeah, I don't either. I'm not an expert in that area myself at all.
But I can leave it in if it makes you feel better.
I think, as you were saying, it's just, it doesn't change what you passed out of this committee
No.
substantively. It's just what justice
No,
oversight.
starting in July, you'll be able to, or is this effective on passage?
It's a good question. Can't remember what I have the bill right here. Yep, it is July 1st.
Yeah. Starting in July, they'll be able to use the doctor level psychologist.
Okay, that's good, because I was concerned. I heard pretty clearly from the judiciary that they need help now.
Yeah,
Yes, that piece
so
is unchanged.
Okay.
Yeah.
on line 9 is B.
Yes. So this was a proposal to allow participation in the justice oversight deliberations on this issue by 2 members of Senate Health and Welfare and 2 members of House Health Care. So basically provides that justice oversight would look at this issue. And again, this is the issue that we're just talking about. Should the range of professions who can conduct psychiatric exam be expanded. So that, when that issue is considered by justice oversight, they specified that it would be at 4 meetings and 2 members of health and welfare, 2 members of healthcare could attend and participate, and they would be permitted to participate in the development of the recommendations as well.
The one question, I don't have a problem with it, but
I
the
think it's
one
good.
question I have for, under open meeting laws, you would have a majority of the Senate Health and Welfare Committee and Justice Oversight at any of these times. Because there's already a member of Senate Health and Welfare on the Justice Oversight Committee. Does that have anything to do with anything?
The only reason I would tentatively say no is at least, and I'll double check this with Michael Grady and Jen, because I think their position is that the open meeting law doesn't apply to the legislature. So that technically, yeah.
I got a quick question, Senator, seriously. Not that I disagree with this either, but in reading this, I'm going, well, isn't this something that should be run by the committees versus can all committees just simply invite themselves to whatever?
Well, I would think the speaker would do the two members from Health Committee, and the Committee on Committees would appoint the two members from the Health and Welfare.
So it has to be run by them,
Yeah,
as far
to-
as protocol.
To be the members on there, because there may be. Yes.
So usually when I see lists of task forces like this, the bill explicitly says two members of the Committee on Health and the Senate Committee on Health and Welfare to be appointed by the Committee on Committees, and two members of the House Committee on Healthcare to be appointed by the Speaker. Does the bill need to say that in order for it to go that way? As it reads, could it just be anyone from that committee who decided they wanted it to be them?
Yeah.
I think that there would be an implied decision maker.
Okay.
And now, that doesn't mean you couldn't, if you decide you want the decision maker to be the Committee on Committees and the Speaker, certainly could put that in. It doesn't say that, so it does leave it open who the decision maker would be. I do think it at least implies that there is somebody. But I don't know for sure whether that was intentional. I'm just not sure whether that was, they wanted to leave that open so that the committee themselves could sort of self-nominate. I'm not sure.
Yeah.
I suppose we could offer an amendment to the amendment to make that clear.
Sure.
That's okay with the rest of the committee.
Fine, either way.
Since there's only three of us in the room, Eric, could you compare that amendment to the amendment?
It would be easier if they agreed. If I could run it, I'd just say, I'll point that out, see if they're good with that, and just they'll add it in.
Yeah.
And then
Yeah.
does that make sense? To see
It
if that-
does. I also so I think it could also make sense that the appointing person be the chair of those two committees, but I do think it is helpful to explicitly say who is going to be.
Yeah, well, normally it is the Committee on Committees or the Speaker. And the Speaker may want to make sure there's representation from different parties or whatever. The chair may not be.
There. Yeah, I don't feel strongly in one way or the other in who should be making the decision. I just feel like perhaps we should name who is going to.
Yeah, I think so. I think you're right.
Okay, shall I run over? See
Yeah,
if I
you
can.
just ask them if they don't want to do it. Or if they don't mind changing their amendment.
Yeah.
But that's only our only suggestion is that they change that.
And that's the only one.
Yeah, I think we're okay with the rest. I mean, I think,
We're easy to get along with.
It's so
well,
true.
I think if it's okay, you're gonna check with Mike and Jen on the three members of health. And welfare. Be on a- It's not a health and welfare meeting.
Great. Yes, I'll definitely run that by them.
Okay. Thank you.
Sure. This will be.
Great timing.
I'll track it down. Okay. Oh, yes. I'll go see if I can.
Question about three members.
We can obviously offer that for third reading if we need to. Eric,
Yes.
since this is second reading today, we could offer our amendment for third reading.
Oh, okay, right.
So
I can't confirm it the
if
next
they
few
don't
minutes.
want to do it now, we
Yep.
can offer that before third reading.
Perfect. Yep, sounds good.
So,
All right. I'll hopefully report back in a few minutes.
okay,
Thanks.
now we're gonna switch gears to S89. Katie's here a little early, which is great. I like being early.
Well, I like being early. It rarely happens for me.
Would you like me to share my screen? Would you like me to share my screen?
Sure.
Okay. So Katie McLean, Office of Legislative Counsel. This is instances of amendment. So if you want to see how the new sections sort of slot into the committee report from this committee, you need to have both documents in front of you. But it probably shouldn't be too confusing since we're mostly just adding new sections. So first, Senate Health and Welfare has selected to add a purpose section to the bill. It is the purpose of this act to enable the commissioners of mental health and of disabilities, aging and independent living to seek treatment and programming for certain individuals in a forensic facility. An initial forensic facility shall be located in the 9-bed unit of the current Vermont Psychiatric Care Hospital. This unit shall be relicensed as a therapeutic community residence.
I'm kind of smiling because I thought that was supposed to be confidential.
Well,
It no longer
the
is, I guess.
departments have been talking about it in committee, so.
Well, people have told me that it was confidential between the administration and certain lawmakers. But it is no longer, it's already out here. That's why I've avoided using that. Not your fault.
I understand it's no longer under embargo. The commissioner of mental health was presenting a proposal about where the facility would be, and we already have in the definition that it would be licensed as a therapeutic community residence.
Well, and I never got the memo that it was okay to discuss the location. Because when I met with them back in January, it was gonna be confidential. We were told not to mention. Top secret,
Well, there you have it.
but now it's out. Okay.
Okay,
I just have a question. By putting, and I maybe think I know the answer, but by putting in statute where this will be, does that prevent it from changing to a different location in the future?
so this language is in session law. Purposely, it's not in the VSA. It still has the weight and effect of law, and it's not legislative intent, but it is a purpose. So we're saying that that is the current purpose of where it will be. It doesn't preclude future forensic facilities from being located somewhere else. If at some point in the future, there's a decision to move the forensic facility to another location, I don't think this precludes that from happening. There might be language at that time to say the forensic facility that's currently in X location will be moved to Y. But this is just specifying what the intent, not the intention, what the purpose is at this point.
Thanks. I appreciate that. It just makes me a little, because I know we had a conversation in this committee about potentially better locations or potentially other ways to do this, or some of the potential downfalls of earmarking these 9 beds. So it just makes me a little nervous to be this specific in the legislation about where they will be. But
yeah,
Karen Barber, I think if we need to talk to her about it.
That's all. But thank you for helping me navigate that.
the committee did consider calling it a legislative intent section and drafting it as intent language and chose not to. So then, because we're putting in a new section 1, we're adding a section 1A, or we're renumbering the current section 1 to be 1A, so that's just technical. There, the second instance of amendment on line 15 is to correct a typo. There's an extra appearance of the word "the," so we're striking through that with the second instance of amendment. And then the third instance of amendment adds 2 new sections, sections 20 and 21 after section 19. The first requires a presentation. So on or before February 1st of this coming year, the 2 departments shall jointly present the following information to Human Services and Health and Welfare. A plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties. Second, a plan for the joint management of the forensic facility by the departments. And third, whether any additional resources are needed for the operation of the forensic facility. The next section is a report annually by January 15th between the years of 2015 and 2030. The Departments of Mental Health and of Dale shall jointly submit a report to the two policy committees containing the average daily census at the forensic facility, including trends over time, the number of individuals waitlisted for the forensic facility and where these individuals receive treatment or programming while waiting for a bed at the forensic facility. Third, aggregated demographic data about the individuals served at the forensic facility. And lastly, an account of the number and types of emergency and voluntary procedures used at the forensic facility. And then we're just renumbering the last effective date section to be correct. And that is the whole amendment.
I appreciate it. We'll consider it friendly, I guess that's how you.
Well, like I said, while I do have a little concern being this specific, given your explanation that it is in session law, it is a purpose section, I'm not gonna not be friendly to it. I will reluctantly call it friendly.
I think it gives you, I don't think it precludes you in the future for coming back and moving a facility from one location for another. It's saying it at this point in time, this is the purpose.
Mhm. Okay.
Okay. Thank you.
Welcome.
Oh, Karen, did you want to comment on this at all? Karen Barber?
Thank you. For the record, Karen Barber, General Counsel for the Department of Mental Health. We also had that concern about the language being so specific to BPCH, which is why we asked for the word initially. So at least it gave us some flexibility. So we are okay with the language as is, but we did have that same concern as has been identified.
Thank you. All right, I guess we're all okay with this amendment. Eric, let's go back to 91. Thank you so much, Katie.
You're welcome.
I know it's never easy, but at least the committee rooms are next to each other.
I know, it's a lot faster.
So here's the house. Used to be in the house being the problem. Health Welfare Committee wants the chair to be able to appoint the two members. I don't care.
Like I said, I don't really care who the appointing body is, and I can see the argument for why it should be the chair, because they've got a sense of like the expertise on the committee. And I can see the argument for why it should be the committee on committees, and I sort of feel like it's 6 of one, half dozen of the other.
Yeah. Well, the house can always change it.
That's true.
Yeah, that's true too.
I guess we'll just live with it, Eric.
Okay.
Thank you for checking.
Yeah, sure.
It was a good pickup that they didn't identify anyone to.
Yes, definitely.
Yes.